all day. I will allow you the final 3 minutes to close this up, and that will close public testimony.
Thank you very much. Well, I am a trial attorney. I'm not the trial attorney in the case, and so I want to make sure I'm accurate, and we're all accurate, and have an accurate understanding. But I do have a court ruling from August 17th with me. And let me preface that by saying I've had an opportunity to review both the city attorney's opinion and the Kane-Balmer-Berkman opinion. And those opinions are generally similar. I suspect all of you have reviewed those. I don't think they're too dissimilar in their analysis of this matter. That similar argument was placed in both demurs and motions to strike to Judge Nevitt. Mr. Zucchett stated that this motion to strike that I discussed earlier was a pre-demur ruling. In fact, if I read this document correctly, which is Judge Nevitt's ruling, it was actually a post-demur ruling, because before ruling on the motion to strike, he ruled on the motions on the demurs themselves. So the demurs had already been heard. Now, this is a tentative ruling. My understanding, again, just from speaking with Mr. Bruins, is that the tentative rulings were all upheld, and counsel maybe could correct me if I'm in error, because I don't want to be in error. That's not my litigation. But in fact, according to this ruling from Judge Nevitt, he denied both your demur and the demur of the city. So in a post-demur ruling, he then denied the motion to strike, which was advanced in points and authorities premised upon these two opinions. So Mr. Zucchett wrongfully suggests that a lawyer has convinced the Homeowners Association that they have a viable lawsuit. In fact, Judge Nevitt, in ruling on the demurs and the motion to strike, is actually ruling as to whether or not the lawsuit is viable. He hasn't ruled that he agrees. Let's be clear on that. I'm not suggesting that. But he has suggested that it is, in fact, a viable lawsuit. And it's a viable lawsuit in the court's ruling, at least at this time, rejecting in part the analysis of both of these memos. And I think that's significant. And I think it's significant your staff didn't tell you that, because it ought to cast doubt on what they are telling you. You've heard from these folks. There's a heck of a lot of issues. A lot of them are being litigated. And I think it would make a lot of sense just to put this on hold until the courts can resolve these issues. I want to share this ruling with you, and I only have one. I'm sorry, I didn't know it was going to become a focal point of the discussion.
Thank you.